Welcome to U.S. Immigration TV. Well, I have some encouraging news for people who are in deportation or removal proceedings. The Department of Homeland Security, or DHS, announced a new initiative or a policy where it will affirmatively or on its own move to dismiss certain cases that are currently in deportation or removal proceedings so that the person can instead apply for their green card with the USCIS instead of in front of an immigration judge. The reason for this backlog reduction initiative is because there are over 1.5 million cases now pending in the immigration courts, and that by dismissing certain cases, DHS could reduce that backlog. Now, if you or someone you know is in deportation or removal proceedings and your case meets the requirements, this could be a great benefit so that the threat and the fear of deportation is no longer hanging over your head. Now let's go through some of the requirements. Number one, what kinds of cases could be eligible for dismissal? Well, the cases eligible for possible affirmative dismissal are those where there are no, quote, derogatory factors, unquote. That means certain crimes or fraud or things like that. And the person has on file with the court an application to register permanent residence or adjust status, which is a Form I-485, and they have a merits hearing scheduled on or after August 31, 2023. For example, let's say a person was placed in deportation and now they're married to a U.S. citizen who petitioned them, and they have an adjustment of status application filed with the court. Well, DHS could possibly file a motion to dismiss and have that case transferred to the USCIS, who would then conduct the interview and adjudicate or approve the case instead of waiting to go in front of an immigration judge who, let's face it, has the power to deport you. USCIS does not. Number two, when and where will DHS file these motions to dismiss? Well, starting already in February of 2022, DHS has already begun this initiative at approximately 24 field locations or offices, and that includes New York City, LA, and Newark. Now, depending on how well this program goes, it could actually be expanded and continued. Number three, what if the non-citizen is not included in this initiative but still wants his or her case dismissed? Well, if your case was not selected for affirmative dismissal by DHS, but you think you could be eligible to adjust status with USCIS, you could still submit a regular request for prosecutorial discretion, as is currently in practice. In fact, I've written many articles and I've posted videos on my YouTube channel, U.S. Immigration TV, that you're watching right now, discussing prosecutorial discretion, the requirements, and the elements. Number four, if a person's case is dismissed, will they have to file a new Form I-485 with USCIS, or will the one pending in court be transferred to the USCIS? Well, the answer is, if a person's case is dismissed, they will not be required to file a new Form I-485 with the USCIS if their pending adjustment or Form I-485 was properly filed with the immigration court, and that includes payment of any required fees, and they have submitted all required documents. Number five, how will USCIS prioritize the scheduling of interviews for cases that were dismissed from the immigration court? Well, if a case is dismissed from the immigration court, USCIS will use the date that the non-citizen filed his or her Form I-485 with the immigration court to determine when their application will be adjudicated at the USCIS. In other words, they will not have to go to the back of the line when the case is dismissed from immigration court and transferred to the USCIS. Now, if your case is in deportation proceedings and you have received one of these motions to dismiss, or if you believe your case qualifies for prosecutorial discretion, you should consult with an attorney to determine the best course of action and to possibly represent you at any future interview for adjustment of status. Now, I know there is a tremendous amount of backlog, not only at the immigration courts, but also at USCIS and at the embassy, with so many people, whether or not they're in deportation, anxiously awaiting to have their cases processed. Now, let's hope the government does more to reduce the backlogs, not only at the immigration courts, but also at the USCIS and at the embassies around the world. I hope you have found this video informative. I'm constantly posting videos on this channel, which I hope you find interesting and helpful to you. So make sure to monitor my YouTube channel, US Immigration TV, where I will discuss this topic and more immigration news in greater detail. So don't forget, like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching US Immigration TV.